So, Scott, let's just start with this is now is this case that we're going to hear, is this going to be the first one that we have the opportunity to sort of hear the or the moot court, as it, well, I guess it's not moot, to hear the oral arguments, I should say?
Well, in real time. So, generally, the oral arguments will generally go up within a day or two. And so if you go to the OIA.com website, which we're now, doing remote exams, so we're trying to having, it's coming up a lot in plagiarism reports, but it is this really useful site. And for almost all major opinions, that from recent decades, you could get not only the oral argument, but if the arguments were read in court, if opinions were announced in court, that audio is there too. The difference is that for whatever reason, the Supreme Court has never offered audio real time. It's a big deal if it even offers audio the same day. My opinion is that's always been dumb. I think that Supreme Court oral arguments should be televised. I think this kind of shroud of mystery that surrounds the court is actually really bad for democracy. Dolly Lithwick had a good piece in Slate today making that argument. So what was different about yesterday was just that the oral arguments you could listen in real time, so that they were done virtually, but there was no tape delay. Reporters could just listen in real time. And that's important because, Lithwick made this point that there are very few seats for the general public at Supreme Court hearings, and even fairly limited seats for media. So this was an opportunity for everybody to hear the arguments in real time, which really was, and it worked fine. Went through order of seniority. So actually, Justice Thomas asked, more comfortable in that setting, actually asked more questions. And there's always been this, obviously I don't agree with Thomas ideologically, but this idea that he's dumb because he doesn't speak in oral arguments is really misguided. The problem with Thomas isn't that he's not smart. That's not the issue. But I think it's just, that legitimately that I think that honestly, these arguments are actually less likely to have grandstanding, that basically, justices actually have to ask questions. They can't it's harder for them to use oral arguments to basically argue with each other with the lawyers there being full. So I actually thought it worked quite well, but it was an opportunity to actually hear oral arguments in real time. I didn't actually listen in because of time zone differences. For me, the arguments happen at 7 in the morning. So I'm only going to listen in if it's a really major case. And they deliberately chose kind of a minor case just to kind of work the kinks out. But it is the opportunity, when, for example, the Supreme Court hears oral arguments in the Louisiana abortion case, or even tomorrow morning when they're hearing another religious freedom case, a contraception case, I may well wake up for that. But I think it's I think it's a great thing, honestly, that, I think people should just be able to hear it, even when they go back to live arguments, if ever. Who knows,
Right.
Trump gets started with this, that I still think that, that they should go back to that. That's something I'm discovering as a teacher, is that honestly having to do remote teaching has caused me to sort of rethink some things that, why was I doing this ever? And I think that we're going to see this too, that I'm hoping the Supreme Court will just see there really was never any good reason not to have the arguments be heard live. Nothing, all the parades of horribles that they expected aren't going to happen. And I'm hoping this will just be permanent, even if there's not video, that if at least people can just listen to the arguments as they're happening.
And let me ask you one more question about that, because, of the process, before we get into the two religious, I guess, rights cases that we heard, that we heard yesterday, as you say, and the one that they're going to hear tomorrow in terms of abortion, all of these. But just one more process question. And to be clear, they're doing this from home, or are they in one location? Because, I mean, as someone who has been doing audio like this for a long time remotely, right, from the guests, there is a distinction between sitting in a room with somebody and getting nonverbal cues, whether it's from the plaintiff or the defense or the other judges. And so tell us how they're doing that.
My understanding is that they're at home. I don't believe they're in a centralized location. I'm 99% sure about that. Just because I think that, because I think the social distancing issues involved, and even if you can keep everybody 6 feet apart, you're still having to travel. You still might have to be in proximity. So I believe that they're just from home. So it's just like we are right now, or anybody doing a Zoom meeting. I believe the justices are just at home, and they're doing it that way. And yeah, you're right that especially doing audio, there are things you miss. That there might be little cues in that. But I think that that's also a surmountable problem. They could also just go to video. There's no reason they can't do that. But I mean, certainly if, I think the current net right now is still, the fact that we can hear the arguments in real time. And again, there are advantages and disadvantages that, not, being home means that you can miss up on some subtle things, some cues. And I can imagine if you're actually making the arguments, and that's why another reason the Supreme Court chose to start with that is that the patent case is being argued by Lisa Blatt, who you may remember from her disingenuous praise for Brett Kavanaugh, but she is an extremely experienced and effective Supreme Court advocate. So she would be somebody who wouldn't be thrown off by that. Certainly, if you were arguing a case in the Supreme Court for the first time, not being able to see some of those cues could make it a little bit more difficult. But on the other hand, at least if yesterday's any indication, it also seemed to be more orderly, less grandstanding in ways that could actually be easier. So, I think that we should keep an eye on that. But I'm not sure that the trade-off won't actually be better for people making the arguments.
All right, enough of that process stuff. I find it really fascinating, and it's just one more thing that I think this era, hopefully not as long as one would expect, but hopefully it won't be. But we'll see. But this era will create some fundamental changes in the way that we function in terms of work and society and whatnot. But on to the substance of the cases that were heard yesterday. Two cases. One was Hosanna Tabor versus the EEOC, and the other is Our Lady of Guadalupe School versus Morrissey-berru and St. James versus Beale. I guess these are combined cases. What are the issues in these cases?
Right. Okay. So Hosanna Tabor is a 2012 Supreme Court case. And this sort of created a ministerial exemption from anti-discrimination laws. So the idea here, so as both the federal and state level, employers are forbidden from engaging in certain forms of discrimination. So under the Civil Rights Act, race and gender, and there's an outside chance that by June that will also apply to sexual orientation. That's a case we may be talking about later this year. And also another law that's relevant here is the Americans with Disabilities Act. So essentially, under Hosanna Tabor, ministers are not, cannot. Those protections do not apply to ministers. And it should be said that although it's not an easy case precisely, but it was unanimous. And essentially, there is a reasonable argument here, which is that the deal the First Amendment, the Establishment Clause, the Free Exercise Clause offers is essentially that, religious organizations are supposed to stay out of the affairs of state, but in exchange, the state is also supposed to stay out of the affairs of religion. And whenever if I'm invited to talk to a conservative student group or something about religious freedom, I always emphasize that point, that the First Amendment is not an anti-religious thing. The whole point was to stop entanglement either way, so that basically religious groups should not have undue influence over the state, but by the same token, they have to be given some autonomy. That you don't want the state to sort of be in the position of making religious groups choose their leaders. So if that opinion is interpreted narrowly, I don't necessarily have a problem with it. What the issue with Our Lady of Guadalupe is that these religious schools are asking for ministerial exemptions for people they classify as secular workers. So these are just ordinary teachers. In one case, a teacher who's passed away and their estate is suing, who just might teach a couple of hours of religion a week, but they don't have theology degrees. They don't lead religious institutions. They're just fairly ordinary teachers who just do some religious instruction. Essentially, if those teachers are classified as ministers, then that would effectively allow schools to, avoid civil rights acts almost entirely. That essentially their employees would have almost no protections at all, because anybody who did any religious instruction could essentially be defined as a minister, and be exempt from civil rights law. And that to me would be pushing things in a much broader direction.
I mean, theoretically, right? If I have a Catholic hospital and my doctors, I tell my doctors, make sure you bless the room when you go in or something.
Right.
Right. I mean,
Right.
then we could just start saying that all the personnel that work in the hospital are sort of, I guess, all anti-discrimination laws are suspended for everybody who works at the hospital.
Yeah, it's and of course the genesis of this was a concurrence written in Hosanna Tabor by Justice Alito, basically inviting litigants to push it further. So there was a classic case where Chief Justice Roberts was able to get unanimity by writing a very narrow opinion, but Alito basically says, let's open the door, wider with these issues that haven't settled. But yeah, I think to push that would be really dangerous, and I think it was Ian Millhiser at Vox, but I know somebody actually, found links to, essentially how religious institutions could basically game these tests and easily classify people as religious employees. So certainly what I think the court should do here is really, I would not overrule Hosanna Tabor, but I would say, this only applies to top religious leadership. If people have a primarily secular function, then they're subject to anti-discrimination laws, and I don't think that would create an excessive entanglement with religion. Then again, I think that there can be some warning, that the government will have to show that an anti-discrimination, or the plaintiff would have to show that an anti-discrimination lawsuit is sound based on the merits, that there's no religious animus creeping in or anything like that. There are safeguards. But this idea that you have to create incredibly broad exemptions to civil rights statutes to avoid violating the Establishment Clause, I think is silly. I mean, I think that religious leadership is a different issue. I think that that's fair. You really want to avoid pretextual. I'm fine with that. But once you start, making that apply to ordinary employees, I think that would be down really far down a slippery slope. But I have to say that it would not be shocking if the Supreme Court, in fact, went in that direction.
Yeah, well, I want to get to that in a minute, because I mean, I feel like there is a there is a real sense, a palpable sense of it's payback time.
Yeah.
We got you elected, Donald Trump. We gave you these opportunity to fill these two seats, and now it's payback time. The religious right is coming back and using these religious exemptions as a way of really undercutting and broadening and rolling back, really is what it is, the protections that we have in terms of discrimination, among other things as well. Let me so how would you, if you were to narrow Hosanna Tabor and make it or clarify and edit, I guess build upon those the footprint that was laid there, how would you make the determination as to what was a primarily secular job? I mean, it seems to me it's relatively easy, but I don't know, maybe it's too broad thinking about it this way. But if I'm a company and I have a job that you are basically doing for a church or for a religious school or hospital, then you're a secular worker, right? Like there's no minister in a company. There is no minister in a restaurant. But there are managers, there are accountants, there are, people who are, doing labor. I mean, so is that how you would set the test, or is that just something that somebody would come up with that?
Yeah, and I think that's what the plaintiffs are arguing here is, that you should, first of all, start with formal titles. So what Alito is asking for is essentially that, anybody involved with kind of religious decision making, there basically doesn't really matter what the hierarchy is, basically, if you're involved. So something like just religious instruction would be enough. Whereas, what the plaintiffs are saying here is the fact that they're classified as teachers and not ministers actually is significant. Now, that can't be dispositive just because, there's sometimes, if you're dealing with the Roman Catholic Church, it's pretty obvious who's in the hierarchy and who isn't, but not all religions are structured that way. So for religions that don't have those kinds of clear lines of authority or whatever, there may be some edge cases where you have to look a little bit beyond the formalities, and kind of look at what somebody's day-to-day job is. But that's the way I would do it. First of all, start with how are these people being classified, and you also have to watch for, that you have to create some kind of language saying that, you can't get around that by just classifying everybody as a minister. There has to be somebody whose primary job is leading religious services or setting the tone or supervising many other employees, something like that. So I think that you start with titles and really basic job descriptions, and then there's going to be some marginal cases, especially if you're dealing with a religious organization that has some kind of unusual non-hierarchical approach or something. But to me, you can't let the fact that that every constitutional law question always has some edge cases. You can't resolve everything. But to me, that's where I would start. But basically, I wouldn't do it the other way. Just kind of preemptively surrender and just say whoever the religious organization says has ministerial responsibilities has ministerial responsibilities. And that's really what Alito wants, is just almost unlimited deference to what the religious institutions say. But that's basically allowing, that's the whole danger that Scalia identified in free exercise cases, that you're basically allowing, organizations that perform secular functions to declare themselves exempt from civil rights laws by just calling everybody a religious employee. And that's obviously really problematic. And especially once you start to get to this idea that corporations can have religious identity, then you're really going,
Right.
which we might get to, then
Right.
you're really, but even just confined to actually religious organizations, I think that's pretty disturbing. And I think that we should be, and again, I think that Hosanna Tabor is fine. I'm not saying that there's no legitimate clash between religious freedom and civil rights acts at all, but I certainly do think that in a secular society, civil rights should be in the preferred position. That any carve-outs to civil rights should be the exception, not the rule, and we should err on the side of not giving the exemption.
Let's pivot to we're recording this on Tuesday, and so what is the argument that we're going to hear tomorrow? Yes. Another religious freedom case. I mean, it's not just me, right? There's a lot of these coming up.
Yeah. Oh, yeah. And I think I think you made a great point in terms of, the sort of payback that there's quite a lot of evidence that it was the Supreme Court and that Supreme Court vacancy that sort of kept evangelicals in line. That sort of all the evangelicals who voted for Cruz rather than Trump, one thing that was able to persuade them to get to the polls, even after the Access Hollywood tape, even after everything, was that vacancy. There's a whole other argument about why liberals do not have the same urgency, and I suspect that that's changing with the Kavanaugh confirmation. But of course, it's kind of closing the barn after the horse is 3 counties over. But definitely, Kavanaugh and Gorsuch in particular, have a very Alito-like view of religious freedom, which is actually quite different than Scalia and Kennedy, quite a bit more conservative. So, one thing is that my guess is that the Roberts Court is probably not going to be super enthusiastic about overruling the Obergefell decision, the same-sex marriage decision. First of all, because I think that would produce a very visible backlash. And secondly, it just doesn't seem to be a big project for the conservative movement as a whole. Somewhat surprisingly, you don't get the sense that evangelical groups are really anxious, that considering how strongly they're imposed beforehand, there doesn't seem to be, it doesn't seem to be a top priority. So one would think that Roberts doesn't really want to go there. If the personnel of the court changes, that could be different. But where I do think you're going to see blowback against LBGT rights is going to be in these cases. Basically saying that civil rights laws don't apply, or that essentially, employers can declare themselves religious and therefore get out of things like providing contraceptive benefits that even if federal regulations require them to be given.
And is that the issue tomorrow?
Yes. So, and this is a little bit complicated. So, many of your listeners will remember the Hobby Lobby case, in which the Supreme Court said that a corporation, at least if it wasn't publicly held, could declare itself to have religious convictions and therefore cannot be substantially burdened under the Religious Freedom Restoration Act. And the court ruled, therefore, that Hobby Lobby did not have to provide contraceptives as part of the health coverage it gave its employees, even though that had been required by the Obama administration. Now, the twist with these cases is that the Trump, one of the many bad things that happens when a Republican administration takes over is that the Trump administration rolled back those regulations and essentially said that if a business had any religious or moral objection to contraceptives, they didn't have to provide it. So what's interesting is that the Trump administration is arguing that under the Religious Freedom Restoration Act, this broad exemption would have to be given even if the regulation was modified. So even if President Biden or President Inslee or whoever comes in office in 2021 and goes back to the old regulation, what the Trump administration is urging the court to do is to say that there has to be a religious exemption that's very broad, even if contraception is again required under the old standard. So that's something that would be a ruling that the next Democratic administration couldn't even change.
Right.
One thing, and we'll have to hear for oral arguments tomorrow. My understanding is that the Trump administration will have a very good chance of winning on the religious exemption. With respect to the moral exemption, that might be a little bit trickier. So that it could be that the Trump administration is allowed to make that change in a regulatory manner. That would be a real stretch. And I suspect that you might get one of those Roberts kind of splitting the baby, kind of superficially moderate opinions that grants a permanent religious exemption, but not a moral exemption, even though practically the difference, I mean, I guess there may be people with a secular moral objection to contraception, like a men's rights organization, I don't know, Colette, I don't know, somebody else.
Right.
Practically almost all, attempts to get a contraceptive exemption are going to be religious or can be framed as being religious. So it probably doesn't, so it's one of the, if so, it would be one of those opinions that's actually not really as moderate as it looks like. But that's, but it'll be interesting to see the oral argument, because that's the big thing, is that it's a classic case where the court can rule narrowly or it can rule broadly. So first of all, it has to decide if the Trump administration did this in a way that comports with, basic administrative procedure. And if it does, it can sort of rule narrowly and say, this, as of now, you have a religious or moral exemption, but, the next Democratic administration can change that back. Or they can interpret the Religious Freedom Restoration Act and say, nope, in fact, even if the next Democratic administration wanted to change, this broad exemption is necessary. Now, of course, this isn't based on the First Amendment. So another thing a Democratic Congress could do would be to modify the Religious Freedom Restoration Act. But that's just a tougher lift, sort of being perceived as, attacking religious freedom, even if it's not fair, is going to be a tougher lift. Plus, the next unified Democratic government really is going to have a lot of things on its plate.
Yeah.
And that's part of it, is that, everything that the Supreme Court can make the Congress clean up is just one thing. There's only so many fights you can have, only so many things on your agenda. So, the next Democratic government is just going to, face a lot of tough choices about what do you clean up from what the Roberts Court has done. What new items can you prepare? It's going to be really tricky. So that's another thing where, even if Congress theoretically can change it, it's a lot harder in practice than it is in theory sometimes.
Scott Lemieux, thank you so much for catching us up on this. I really appreciate your time today.
Yeah, thanks a lot, Sam. Take care and hang in there, and we'll talk to you soon.